I'm asking you to do this off the cuff today, but the first point I should make, really, is that prepping for a moot, so preparing and doing your research, actually takes a really long time. I've given you a simple problem today because I think it's quite accessible and I think we can have a meaningful discussion about how would you tackle your arguments. But in a real mooting scenario, you really need to put some time and energy to the research. So in a real mooting scenario, this is why it's a good idea to do your prep as a team, because you really need to read around the topic, you know, and not just read in the textbooks, but to actually go into the law reports and read all the cases on the points that you've identified, and then read the cases that are referred to in the cases on the points that you've identified. You know, you really need to understand, to have a very firm grip on the legal issues involved, so that you can cope with questions, you know, so that you can cope with unexpected submissions from the other side. So the first point I would make is, this is not a very realistic exercise, because I've asked you to do it off the tops of your head, but real moot preparation is a very time-consuming, full-on research exercise, and that's why it's a good idea to do it as a team. Okay. The problem I've given you, I think, is straightforward, because it contemplates issues around offer and acceptance and intention to contract and contract formation and things of that nature. So, you guys, I asked you to think about what kind of things is the appellant going to argue? What kind of points would you raise if you were acting for Richard?
That offer and acceptance have taken place with reference to the postal rules and the electronic communication.
Okay, so we would say there is an offer and acceptance. Yes. What else? What else might he argue? There is an offer, and the email was an acceptance. What else can we say? What else can we anticipate that they might argue?
They might argue unilateral mistake.
Right, okay. What would we say about that?
Whereby a mistake occurred, typographical or whatever, but both, or one party took advantage of that mistake, which they knew to exist, and they made their offer.
Okay, all right. Well, let's jot that down then. So we know there might be an issue around mistake. How are we going to deal with that? We need to come up with some arguments to refute the question mark over was there a mistake. In other words, was the seller mistaken? And might that vitiate the contract? What else might we say?
Question about whether the terms and conditions were incorporated.
Yes, what about the terms and conditions? We need to say something about were those terms and conditions effective.
So you could say that Richard was only given his attention to the terms and conditions after, like, offer and acceptance had gone through. You know, like, they only said to him, "Oh, have a look at our terms and conditions," after there was an offer and acceptance.
Yes, that's right. So timing, isn't it, where they incorporated
Okay.
into the contract. Yes, good, but that's right. Anything else? In terms of brainstorming, what other things might you talk about?
Unfair terms.
Yes, what about unfair terms? Unfair contract terms? Yes? Might there be something in consumer law? That we could research? Other ideas? What about intention? There's clearly going to be an argument about intention, isn't there? Was there an intention to create legal relations? That needs to be in there somewhere. Now, this is a bit laborious, isn't it? But what I'm suggesting that you do, in the first instance, having done your research and had a read around the problem and identified some authorities, in terms of constructing your argument, the first step is to kind of mind map it in a way like this. Because to come up with a successful and persuasive speech, what you want to end up with is not the whole thing written out verbatim, so you're just woodenly reading along the lines, because that is not very persuasive. What you want to come up with is a number of separate lines, separate elements to your argument, okay? Separate zones in your mind map that you can shuffle around if you need to. You know? So you're kind of bite-sized chunking the work. So rather than preparing one massive long story that you're just going to stand up and tell, I would suggest to you, you're actually constructing a number of mini arguments that will work together, but you can detach them, you can shuffle them. If one of your points becomes redundant, if you begin talking about one of your points and the judge interrupts you, and you then have to abandon it, you need to be flexible enough to shuffle them around in terms of order and importance. And in your team, you might decide, you know, one of you will prepare, or one of you will research one of these elements, and divide them up between the team. You can get some really deep research on each one, okay? What about on the other side? Just give me an idea of what kind of issues you might talk about.
They've covered themselves with terms and conditions where they say the acceptance isn't going to take place until you receive the order that your item's been dispatched.
Good, okay, so respondent will say the terms and conditions are effective, okay, because they say the offer's not accepted until the item's dispatched. Good, okay. What else? What other points did you come up with? But the other side have kind of fed you some ideas.
Right, again on the fact it was a mistake and a unilateral mistake.
Right, so you guys will say there was a mistake, there was a unilateral mistake of fact which vitiates the contract.
Any agreement, maybe?
It was clearly a mistake. Anyone would realise. There was a real case like this, wasn't there? Do you remember when Argos put some TVs for £3 on its website? Clearly a mistake. Anyone would recognise that was a mistake. Good. Okay. What else might we say?
I'm not sure, I don't really know much about contract law. Could they argue that the sign for the £109 was an invitation to treat, and then the appellant made an offer but they didn't actually accept it?
Right. Okay. Good. So there you are. One of your ranks has gone renegade now. But look, maybe you will say there's no offer and acceptance here. And again, so again, you're going to need to research this. You're going to go right into the case law of what's an offer and acceptance, what's an invitation to treat. Do you remember goods being displayed in the shop window, and how do we categorise them? Yeah? Good. Okay. Other points you came up with? What else might you mention? Do you have to give me the law? Just give me some ideas of arguments that you might run.
Will clauses come into place, like exclusion clauses?
Okay. Exclusion, all right, let's put that down then, as we're mind mapping. Exclusion clauses, yes, we might need to explore. And certainly, if the appellant raises something around unfair contract terms and exclusion clauses, we'll need to have an argument to deal with that, won't we? Yes, good. What else? What about intention? So can we have a cumulative point here that says we don't think there was an offer and acceptance, but even if there was, we'd submit there's no intention to create legal relations, no intention to contract. Good. Other ideas? Might we say something about damages? Do you remember we talk about remoteness of damage in contract? Could we say, even if, we don't think there's an offer and acceptance, but even if there is, we don't think there's any intention to contract, but even if there is, we think that might be vitiated by a unilateral mistake. And even if that isn't an effective vitiating factor, we think the damages are too remote to claim. Do you see? So you're accumulating points on points on points. Even if you don't accept my first point, let me show you some other very compelling submissions. All right. So I think the first step in terms of constructing our argument is to do this exercise, to kind of mind map all of the arguments that we might possibly run. Right? And you will find that some of your lines of argument, some of your submissions are positive. They are advancing your own case. We think there definitely was a contract here, because we can clearly identify an offer and acceptance. So some of them are positive. Some of them will be negative. In other words, they are refuting the arguments the other side is coming up with. For example, we've heard that you might run an argument around unilateral mistake, and we will address that in a negative way. Okay, so some of your points will be negative ones, or positive ones, putting your own case forward. Some will be negative, refuting the other side's points. And generally speaking, in terms of the order of your submissions, the positive points should come first, followed by the negative ones. Right, so all the reasons why you are right should appear first in your argument, followed by the reasons why the other side are wrong. And because when you're mooting you are time limited, it makes sense to put your strongest arguments first, followed by the ones you think are less strong. And that's counterintuitive, I think, to us as mooters, because the temptation, I think, is to start off with a point that's quite good, build, and then, you know, kind of Perry Mason style, finish on a fantastic high. But the reality is, you won't have time. So, as part of this exercise, I would suggest to you, you need to, together in your teams, you need to identify which of these points are your real money makers. You know, which are your absolute killer points, because they are the ones that you need to address first. If you run out of time, hopefully it's your weaker points that you run out of time to discuss. Yeah. And actually, you may decide, based on the amount of time available, that some of your points are so weak, you can jettison them. You're not going to run them at all. In terms of constructing a convincing argument, there is nothing to be gained from adding weaker points onto stronger ones. You know, you are better off with a few really good money-making killer points that you can explain in detail and answer questions on. It's much more compelling and persuasive than a huge long list of arguments that get progressively weaker and weaker and weaker. Okay. So, what have I said so far in terms of my top tips? Don't write it all out as a big long speech. Think about bite-sized chunking your arguments so that you can switch the order if you need to. You can jump from one to another if you're prompted to do so. Try and put your positive points before your negative ones. You're advancing your own case before you're trying to knock down the other sides. Try and identify which one or two of your submissions are your absolute killers, your money makers. Because they are the ones that need to come first, have the most time spent on them, and be the most convincing. When you're constructing your argument, I said a moment ago, you're going to be arguing your points either cumulatively or in the alternative. So cumulative, your positive points, they're relatively easy to do. So you're building on, right, you know, we think there was an offer and acceptance. And also, in addition to that, we submit there is an intention to create legal relations. And we can identify the terms of the contract. Okay, so you're cumulatively building. Some of your points you will need to argue in the alternative. All right, so on this kind of side of the board, we've got some more alternative points, haven't we? Because we are saying there can't be a contract because there's no offer and acceptance. And even if there were an offer and acceptance, we still don't think there's a contract because there's no intention to contract, to create legal relations. And even if there is an intention to create legal relations, we think there's a unilateral mistake that vitiates the contract. And even if we don't accept any of those submissions, we still think that the appeal should be dismissed if the damage is too remote to be claimed in contract. Okay, so your submissions are kind of coming out in the alternative, aren't they? Here's an argument. But even if you don't accept that, what about this point? And even if you don't accept that, here's another compelling point. Do you see what I mean? So you're kind of reasoning through what all those arguments might be. Now, in terms of how you navigate your way through all the points on the mind map, one of the things to be aware of when you're mooting, you know this already, I guess, is that you'll be interrupted all the time. You know, so you'll come with your well-prepared arguments, and as soon as you get into full flow, the judge will interrupt you. Now, some of those questions you'll be able to predict, you're confident to deal with. Some will be totally irrelevant, and they're just there to put you off your stride. And so I'd say two things about that. I know you've learned how to respond to them. The first thing I would say is, I suggest, when you're working through your argument, minimise the opportunity for the judge to interrupt you by keeping up a flow all the way through. And do that by using linking words and phrases. So, you know, perhaps you're talking about, oh, well, you know, it's our submission that there is an offer and acceptance here, and this is where they are, which brings me on to the next point of my argument. You know, and because if you pause, any kind of lengthy pause in your submission is an open invitation for the judge to wake up and ask you a hard question. So I think when you're putting these points together, and practicing them, I suggest work on that continuous flow and using linking words, and don't leave any openings or gaps, because that's just asking for difficult questions to be posed. The other point to make about questions is, as I said a moment ago, sometimes a question will be so difficult you have to abandon part of your argument and move on to another bit. Sometimes there might be merit in the question, it might be something you haven't thought of, or maybe there's a reason why one of your authorities is totally irrelevant, and that happens. You know, that's okay. At that point, it is better to jettison that point and move on to the next part of your argument. And that's why the kind of mind map model works so well. I think while you're beginning with your strongest points, because hopefully you've got through them by the time you get to the difficult questions. If you don't cover all of the arguments you've identified in the time available, nobody will know except you. You know, which is why I say start with the strongest ones, start with some of your big hitters, make sure you've covered those and explained them in a satisfactory way. So that if your time runs, if something goes really wrong, or if you have lots of questions that eat up time, and you find you're cut short, you know, nobody will know that there are things you didn't get to except for you. In which case it doesn't matter, but you still cover the main points of your submissions. Shall we have a little practice? Is it worth practicing? Let's do some, let's introduce some of these points, and then I think let's work our way through using our linking words and phrases, trying to introduce our submissions and build them onto each other, and then let's think about how we might conclude with a really powerful, punchy summary at the end of the argument. So, how far have you gone with your courtroom etiquette? Do you know how to introduce yourselves, explain the nature of the appeal? Okay. You guys for the appellant, does somebody want to have a crack at just introducing themselves and explaining the nature of this appeal for us? There's no pressure. I won't know if you do it wrong. Someone feeling brave? It's got to be one of you guys. Yes, go on then. Thank you. All right. Yeah.
I've got any meetings.
Thanks.
My lord, I am David. I am Mr. Ayton, appearing on behalf of the appellant, Richard. The appeal stands that Amazon.co.uk Amazing.co.uk was in breach of contract. It is our submission that Amazing.co.uk was in breach of contract when they cancelled Richard's order of the 8 GB 8-bit iToy MP3. Our appeal is made on two submissions. The first submission is that there is an offer, there was an offer and acceptance. The offer was made by my client, Richard, and the acceptance was made by Amazing.co.uk when they sent the email.
Good. Yeah, good. Fantastic. Thank you very much. Good start. Good introduction. Yeah, I think that was good. That was clear, wasn't it? It was confident. Anything missing from that? I'll put you on the spot now, and I know that I'm being unfair. Anything missing from that summary? Yeah, someone else have a go. How do you introduce an appeal? So you're right to introduce yourself and say who you're speaking. Right? What does the court need from you then, by way of introduction? A brief summary of the facts. Yes. Succinct summary of the facts. Then what else? Good. The decision that you're appealing from. Yes. And then the grounds of appeal. Yes, the nature of the appeal. Good. All right, so it's the court where we are, yourself, a succinct summary of the facts, the decision that you're appealing from, and the grounds of the appeal. Okay, good. Someone else have a go then. Don't mind too, but the objective today is to get us all on our feet and get used to speaking in a safe environment. Good, thank you. Go on then, let's have another go.
Good afternoon, my lord. My name is Mr. Ridge. I appear in this case on behalf of the appellant. The facts of this case are that in January, Richard purchased an MP3 player for £109 with free delivery. This turned out, the listing turned out to be a mistake on behalf of Amazing.co.uk, who will attempt to claim a unilateral mistake. However, it is our submission that our client was not aware of the mistake. He legitimately believed that to be the offer, and in purchasing the product, he accepted the offer. Thank you. That concludes my submission.
Good, thank you. Very good. Very good. I like your confidence. That was very convincing. Okay, good. Feedback? Anyone got any ideas of how they might do it differently? Anything that was maybe missing in your introduction? Notwithstanding it was good and it was confident, convinced us. Yes, I think that's right. So I think in your eagerness, you kind of confounded the argument with the facts. So in terms of your introduction, what we need is what you guys have done, who you are, who you appear for, a quick summary of the facts of the case. At that point, I think, you began explaining, but actually, here's the real facts, and this is what we really think happened. But what we're looking for there is a succinct summary of the facts. And in your mooting problem, you will be given facts which are not in dispute. The facts are never going to be in dispute. It's only the law that's in dispute in your moot problem. Okay? So the facts are always going to be clear, and you will have a first instance finding of fact, and you can accept it, and you're never going to be asked to speculate on the facts. Okay? So facts, no argument in there. The decision that you're appealing from, so you need to explain what was the decision at first instance or at the next lowest court. And then the grounds of the appeal. The grounds of appeal are not the same as your argument. The grounds of appeal are the reasons why you've been given permission to appeal to the court we're in now, which is the Court of Appeal. Okay? So, and all of that needs to come out before you begin your argument. Okay, so it's slowly, step by step by step. And having done that, there will be time to begin on your submissions, but it's step by step by step. Right. Having done that introduction then, having explained what was the decision and what are the grounds of appeal, how do you begin putting forward your argument? Let's think of some forms of words that you can use to get your argument off the ground. So we've said, this is who I am, this is the decision, and this appeal was granted on the grounds that the contract was formed, and that it was not unreasonable for Richard to assume that the advertised price was genuine, so there was an intention to contract. Pause. How do you begin your argument? Yes, good, okay, so, and that's a good form of words, isn't it? May I begin, my lord, may I begin with counsel's first submission. It's a good idea to decide which points you as leader will deal with and which points your junior will deal with, so that you're signposting all the way through where you are in your argument. Okay, so perhaps going even one stage further back, I will deal with the question of offer and acceptance, and my learned junior will then address the issue of whatever it is, mistake, or whether the terms and conditions were incorporated or whatever. Okay, so you're quite clear, you're signposting so the judge can follow you through your story, through the narrative of your argument. Which points will you deal with and which will your junior deal with? Right, if I may begin with my first submission, which is this. And then remember we said, as you work your way through the argument, trying not to leave any big pauses, because that's an invitation for difficult questions. So, this is the situation. Which brings me on to my second submission, if I may. And furthermore, here is my third submission. And I'm just going to keep talking to make it very difficult for you to interrupt me and put me off my flow. Okay. If that happens, in your mind map, you have like a 2-line summary of all your key points. So if it happens that you're thrown off by a difficult question partway through, in here or in your notes for preparation, you've got a 2-line summary of all of your key submissions. So that if you find at the end that you're in a massive rush to get through the material, you can do so relatively quickly, rather than jettisoning points that you've identified as important. What about concluding? What about concluding your argument? You are time constrained, but it is really important to be clear what you are asking for at the end of your submissions. So think about, perhaps as appellants and respondents, take a minute to think about what are your final 2 lines going to be? How are you going to wrap up your argument? What are you asking the court for? Just take a couple of minutes in your big groups to think about what your concluding lines are going to be.
Have you been in there?
What, mine?
How are we doing then? What are you going to ask for? Now, this is important, isn't it? In terms of ending on a high. It's a really authoritative statement. So, we're asking for the appellant, aren't we? What are you going to ask for? In conclusion, what are you requesting the court to do?
You see something like, on the basis of my submission, my lordship, I believe that this conviction should be squashed. Squashed? Yeah. Squashed.
I like squashed.
Yeah. Squashed. This conviction is unsafe, or it's safe.
Right, okay. Now, this is really important. So this has drawn out an important point about mooting, which is that so far, I think, most of your mooting experience has been criminal,
Yeah.
hasn't it? But remember now, we're looking at a civil matter, okay? So and this is, that's kind of the point of asking the question, so you just walk into my bear trap. But this is it's important, isn't it? Because all of your fantastic argument is going nowhere if you're not really clear about what you're asking for. And all of your moot problems are going to be appeals, aren't they? It's always going to be an appeal so that the facts aren't in dispute, so that you're only going to be talking about law. So I think this is another one of those forms of words that it is useful to have to wrap up really confident, really practiced. So an appellant in a civil appeal, what are you asking for?
The decision to be reversed. The decision of the court first instance to be reversed.
Right, yes, so you're asking for that decision to be reversed, or in other words, what do you want to happen to your appeal?
Succeed. Be
Okay.
held.
You guys want it to be dismissed, you guys want it to be allowed. Right, in conclusion, I request that this appeal be allowed. Right, you're the appellants. In a civil case, you want the appeal to be allowed. And what else are you going to ask for? Right.
What damages you want to
Right, so you're going to ask for the appeal to be allowed. You're claiming damages, aren't you? So we ask for the appeal to be allowed and that the appellant be awarded damages. And what else do you have to think about in a civil claim? Yes, good. Costs. Because we're in the Court of Appeal, aren't we? The costs are going to be stratospheric. So in a civil claim, as the appellant, you're asking that the appeal be allowed, that the appellant be awarded damages and costs of the appeal. Civil claims, don't forget to ask for costs. That's an obvious thing that we picked up on. What about you guys, the respondent? What are you asking for? We ask for the appeal be dismissed. No damages to be awarded? Right, and for the respondent to be awarded costs. Yes, good. Okay, so in a civil matter, that's your conclusion. In conclusion, my lord, I submit the appeal should be allowed and damages awarded and costs, or that this appeal should be dismissed and the respondent awarded costs. Okay, and you know, lots of your moot cases will be civil type matters because there are so many more difficult areas and difficult claims that might come up. Okay, what else do I need to tell you in my 10 top tips of constructing an argument? Well, I've talked about don't write it all out verbatim, have a little mind map, have a 2-line summary of each of your points so that you can be natural, so that you can shuffle the order if you need to, you can move around if directed to do so by the judge. The other thing that you must do is listen when the other side are talking. And so this is the thing that's going to really win you points in mooting. It is really tempting to kind of see it as a performance, you know, and go with all your fantastic points, say them, deal with a few questions, and then you're so relieved. you don't really hear what else goes on. But you must listen to the points the other side are making. Because if they come up with something unexpected and you ignore it, that looks bad. It's not going to win you any points. So you need to listen and acknowledge the points they've made. You know, but we submit that case is readily distinguishable from the instant one. You know, it is our contention that, in fact, we would direct you to this other authority on the point. And that makes for so much more credible mooting. So if you can acknowledge points the other side have made and explain why they're wrong, or yours are better, that will improve your performance enormously. And similarly with questions, it sounds stupid, but if you can possibly listen to the questions being asked before you start to think about the answer, again, you're likely to perform better. So, some questions you will be asked just to throw you off your stride, and they will be stupid questions or impossible to answer. And you just need to take a moment to think or listen even before you think about how you're going to deal with them. And you might decide, I accept that point, and if I may, I'll now move on. Okay. What have we talked about today? We've talked about how to introduce your arguments, haven't we? How to get your submissions going. We've talked about all the research that you will need to do. Now, this exercise is quite difficult, where I've just given you a problem now and gone, come on, tell me some law. I think it's quite simple, but, really, if you take nothing else away, don't underestimate the amount of time you will need to spend reading and researching. So whatever the issue, you need to know it.
I hope everyone joined us had a impact week.
Very well, thanks. You will need to know it so well. So actually, in your team researching, it's a good idea to kind of sit around and have like a round table discussion on those different points. Just to make sure that you've bottomed out everyone's understanding. And difficult points to argue them back and forth before you even embark on this mind mapping exercise, just to make sure that everyone fully understands. But you really must go back to the cases, go back to the judgments and read them and reread them. Actually, if you can incorporate snippets of judgments into your arguments, they're so much more compelling. Moot judges love that. If you can incorporate quotations from judgments into your arguments, that's a fantastic tip for mooting success. But it does require you to go back and read the judgments, and read them again, and talk about them, so you really understand them and know them inside out. We've talked about kind of bite-sized chunking your argument, and you're not writing out a full speech, you're just giving yourself little prompts, but you will need a short summary of each of these points, just in case you're thrown off your stride and you want to quickly make them before the time runs out. We've talked about identifying which are your probably one or two absolute killer points that you must make thoroughly before you move on. If you don't get through all the points in your argument, that's not the end of the world. That's not necessarily fatal. It doesn't automatically mean you won't win. Nobody will know apart from you. But you must put the most important ones first and the positive ones first. Talked a bit about dealing with questions. Listen to the other side when they make their submissions, and make sure that your conclusion is phrased in the correct way. You're asking for the right things. And again, these are all things that you can prepare in advance to give you a little bit of comfort when you're on your feet, that you've got a sound beginning and a sound ending. I think that's all I have to say about drafting that argument. Questions? Observations? I think you're at the point, you guys, as a team, are at the point where probably reasonably good on the etiquette and the process, and the real hard work is in the research and the law. Because mooting at heart, as I said at the beginning, the etiquette process, the wigs and gowns, is important and it's fun, and that's part of the theatre of it. But the moot is won or lost on the intellectual quality of your argument. And that is really the key to success in mooting. And there are no shortcuts to get there other than reading, researching. And doing it as a team is a great idea because you can discuss ideas with each other. But actually, that's what mooting is. It's an exercise in intellectual persuasion, intellectual argument. And if that's not there, no amount of theatre will carry you through. Okay? Finish there. Thank you, everyone.